Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 80. This week we're looking at three cases, and the first is a Court of Appeal decision which considers whether an individual can bring a claim under the Protection from Harassment Act 1997, even though the harassment was not targeted at that individual. And this case, it follows the trend of recent expansive interpretations of discrimination law that we've seen in the courts and tribunals. The second is an EAT decision concerning service provision changes under TUPE, and it focuses on whether employees who were absent from work due to a temporary layoff at the time of the alleged transfer could be part of any organised grouping of employees that would transfer. And in the third case, the EAT looks again at the public interest test that must be satisfied in order to bring a successful whistleblowing claim. Just before we go any further, I ought to say we're recording this 24 hours later than normal for a number of reasons, not least of which was I was extremely hoarse at the beginning of the week, having been at the Scotland-Australia rugby game. I don't think I've been at a rugby game with an atmosphere like that in my life before. Quite amazing, although sadly, with 5 minutes to go, I did predict what the outcome would be, i.e. Australia penalty in the last minute of the game. There was a grim inevitability about it if you're a Scotland rugby fan. Anyway, back to business. Levi and another against Bates and others. This is a Court of Appeal decision which looks at a claim under the Protection from Harassment Act 1997, and the claim was brought by the wife of the individual who was targeted by the harassment. And whilst the claim is not in an employment context as such, it raises a number of interesting points about bringing a claim for harassment under the Act, which would be equally applicable in the employment sphere. The facts of the case are quite complicated, and they involve the affairs of Leeds United Football Club. So I'll just summarise the key details. One of the claimants, Mr. Levy, was a businessman, and he was involved in taking over the Leeds Football Club in 2004. The other claimant was his wife, Mrs. Levy, obviously, and the main focus of this case involves the claim brought by her. The defendant was Mr. Bates, who took over the Leeds Football Club at a later date, and during that time, Mr. Bates, during the time that he controlled the club, he was entitled to publish material in the club's match programme, which had the potential to reach, they found, almost 100,000 supporters. The key events that gave rise to Mrs. Levy's claim for harassment involved a number of publications in the match programme. First, Mr. Bates published Mr. Levy's home address in the programme, asked readers to make Mr. Levy justify certain decisions that he made when he had been the owner or manager of the football club. In a second publication, Mr. Bates was again raising allegations about Mr. Levy's behaviour, and he made the readers aware of Mr. Levy's home telephone number. There was some attempt to blank out some of the material in terms of some black marker pen, but it was argued that this was completely ineffective. Anyway, the general effect of the publications was that Mr. Bates was inviting supporters to take his sides in the business dispute between the two men, and he was asking supporters to confront Mr. Levy about his alleged dishonourable conduct, either by use of his home address or telephone number. Pausing there, it's probably worth just setting out the key provisions on the Protection from Harassment Act. Section 1 provides that a person must not pursue a course of conduct which amounts to harassment of another, and which he knows or ought to know amounts to harassment of that other. A person who pursues such a course of conduct will be guilty of an offence unless they can show that the pursuit of the course of conduct was reasonable. If a person is found guilty, he is liable to imprisonment for a term not exceeding 6 months, or a fine, or both. In order for something to constitute a course of conduct, it must involve conduct on at least 2 occasions. A claim under the Protection from Harassment Act is open to a whole range of people. Any person who's been harassed due to the unreasonable course of conduct pursued by another individual can bring a claim. It's not limited to particular groups or particular situations. It doesn't have to have a work link, for example. Another important factor to bear in mind is that whilst there is nothing in the Act which states that any course of conduct must be specifically targeted at an individual, there has been a line of case law authority which has established that a case will only be successful under the Act where the individual can show that the conduct was in fact targeted at someone, rather than simply the world at large. This case is novel in that it tests the boundaries of the need for the conduct to be targeted. Mrs. Levy submitted that even though the treatment was not targeted at her, apart from one single exception, the course of conduct, the targeting, was clearly targeting her husband, Mr. Levy. But she said she still suffered a detriment because of the harassment, printing phone numbers, addresses, etc. The High Court judge accepted that Mrs. Levy was very concerned about the publication of her home address and telephone number in the magazines. However, the judge went on to find that none of the relevant publications in fact targeted her. The judge found that although her husband was clearly targeted by the course of harassment, Mrs. Levy wasn't targeted herself, and therefore her claim failed. The judge didn't go on to consider whether a claim could be brought under the Act where the conduct was aimed at a particular victim, but it was foreseeable that harm would be caused to another person because of her proximity to the intended victim of the harassment, as in this case, where the harm could have been caused to Mrs. Levy due to the fact she lived in the same house and shared the same telephone number with Mr. Levy. Mrs. Levy appealed, and the Court of Appeal allowed her appeal. The court held that so long as the conduct was targeted at someone, the conduct complained of did not need to be targeted at the claimant, so long as it's foreseeable that another person would be directly distressed by the harassment. The Act only requires the claimant to be a victim of the relevant course of conduct. It does not preclude a claim whereby the victim of the course of conduct was not the person targeted. However, Court of Appeal did emphasise that Mrs. Levy would have to go further than showing she was distressed merely out of sympathy for her husband. Mrs. Levy had to show that she was directly impacted by the treatment or conduct. Now, I think this is an interesting case. We don't often see claims brought under the Protection from Harassment Act where the person bringing the claim is not the person targeted. And this judgment extends the potential class of individuals who could bring a claim under the Act beyond simply the targeted individuals to those who are foreseeably and directly harmed by the particular course of conduct. And the court didn't agree that this opened the floodgates to claims because the additional class of potential claimants is narrow. In this case, it would only have extended to Mrs. Levy because she shared a home with Mr. Levy and their phone numbers and addresses are being published. It could, I suppose, have extended to other family members too. At one point, the Court of Appeal referred to anyone who was old enough to answer the doorbell or pick up a phone would potentially have had a claim. Ultimately, I think the decision is a very sensible one. Mrs. Levy was a clearly foreseeable victim of the harassment, and Mr. Bates ought reasonably to have known that his conduct would have a direct and detrimental impact on her, even if his main target was Mr. Levy. In essence, this case is another example of the trend in recent times to allow associated claims under discrimination law, and marks another step towards a general extension in protection. And whilst this isn't in the employment context, it is possible for employees to use these protections to bring a claim for harassment outside the scope of the Equality Act 2010. And the benefits of this are, of course, that the individual has 6 years to bring a claim under the Protection from Harassment Act rather than 3 months, as under the Equality Act, in general terms. Also, individuals may prefer a claim under the Harassment Act because you don't need to show that the harassment occurred in connection with a protected characteristic, as opposed to, say, victimisation in a discrimination context. There's no defence for an employer to show it took reasonable steps to protect the harassment if it's an employee's agent that is doing the harassment, but the employer is vicariously liable. I still think it's going to be rare, however, that cases will be brought under the Act, and I suspect the harassment, bullying, victimisation provisions, etc. under the Equality Act will remain far more common, because claims under the Harassment Act have to be brought in the county court, and therefore potentially significant fees have to be incurred, and costs may be much more of an issue. I think the main point for employers coming out of this case, well, if you're looking to settle claims brought by someone alleging harassment against them, then it may be worth ensuring the settlement of those claims covers any claims that could have been brought by third parties arising out of that particular course of conduct. So the family members in this particular case. Here, and I'm generalising and summarising somewhat, Mr. Levy's claims had already either been litigated on or settled. So I'm sure Mr. Bates would have viewed Mrs. Levy's claim as the employer, Mr. Levy, having a second bite of the cherry. As I say, I think it's going to be quite rare that this is relevant, but it's probably a point to keep your eyes open for. So that's Levi and another, and Bates and others. Next case is Inex Home Improvements Limited and Hodgkins and others. So this is an EAT decision concerning service provision changes under TUPE. The case considered whether employees who were absent from work due to a temporary layoff at the time of the change in contractor could be part of any organised grouping of employees that would transfer to that new contractor. By way of background, where a service provision change arises under TUPE, for a transfer to occur there must exist an organised grouping of employees who have, as their principal purpose, the carrying out of the relevant activities on behalf of the client. This case, together with the earlier one of BT Managed Services and Edwards, which we talked about in podcast 78, demonstrates it's no easy exercise identifying the organised grouping of employees due to transfer under TUPE in the context of a service provision change. Key facts for this were that Inex had employed the claimants to carry out work on a building project for Sandwell Homes. The work was to be completed in tranches, and once one tranche of the work was completed, the claimants, the employees, were temporarily laid off until the next tranche of work commenced. Importantly, they remained employees of Inex as it was anticipated that further work would be available following these temporary layoffs. However, at one point, the next tranche of work on the Sandwell Homes project was awarded to a different contractor, Local Run. The claimants, who had been temporarily laid off immediately before the service provision change as part of the normal course of business, brought a claim in the Employment Tribunal against Inex and Local Run, claiming their employment had transferred under TUPE to Local Run by way of a service provision change. Although the Employment Tribunal itself agreed with the claimants there had been a service provision change under TUPE, the Tribunal found the employees did not transfer. Tribunal's reasons were that the activities performed by Inex under the Sandwell Homes contract had come to an end before the service provision change, that tranche of work had been completed, and at that point the claimants had been laid off prior to the date of the transfer. No suggestion the layoff had anything to do with the transfer. The Tribunal therefore concluded that at the time of the service provision change there was no longer an organised grouping of employees which had, as its principal purpose, the carrying out of the relevant activities. In other words, they looked at it as a test that one looked at on the day of the transfer. But the EAT disagreed. It held that neither case nor law TUPE itself required the organised grouping of employees actually to be engaged in the relevant activity immediately before the service provision change. Indeed, the EAT applied a purposive approach to TUPE, concluding that, quote, common sense suggests that a temporary cessation of employment, including for the purpose of holidays, sickness, or expressed to be temporary layoff, should not of themselves deprive employees of their employment if there is a service provision change during the period of temporary cessation. Unquote. The EAT felt that the cessation of work here was temporary. It considered there was a clear expectation that the work would continue beyond the date of the service provision change. So, in coming to its decision, the EAT made comparisons of the claimant's circumstances with a temporary cessation of work in circumstances of sickness or holiday. The EAT concluded that such temporary absences should not deprive employees of their employment. Clearly, the statutory intention of TUPE, as protecting employment, should remain in play during any impermanent cessation. The EAT said that finding otherwise would result in a significant gap in TUPE application in the context of service provision changes. However, the EAT noted the facts of this case were based on the cessation of work being temporary and not permanent. In deciding whether the organised grouping of employees continued to exist at the point of transfer, it was therefore important to consider the, quote, purpose, nature and length of the cessation, unquote. It was decided that a temporary cessation of work does not automatically disqualify employees from being assigned to an organised grouping of employees who would transfer. The EAT therefore sent the case back to the Employment Tribunal to determine the factual issues and whether or not transfer had taken place. This case highlights the complexities of TUPEs, the continuing complexities of TUPEs, and the difficulties that can arise when determining the organised grouping of employees. And we also saw this in the BT Managed Services and Edwards case that I mentioned a few minutes ago. It's a common concern for those who regularly provide contracting services to clients, and it's a common concern to employers who are frequently negotiating outsourcing or insourcing agreements. And the case clearly demonstrates the importance of actively managing long-term absences and emphasises the need for advanced consideration of employees who may be affected by any transfer. Such preparation should allow adequate time for any legal or practical issues that may arise pre-transfer when determining which employees will go across. Indeed, I think for practical purposes, and most employers, where there's a service provision change, it would be unusual that the entire grouping of employees will be laid off at that point of transfer. Instead, I think it's much more likely that some individuals may not personally be actively engaged in the service at that point, but they are temporarily laid off or temporarily reassigned elsewhere. And the issue is whether they too will transfer. The other point of interest is that had this been an ordinary transfer under the alternative approach, the old TUPE Spikers test, I think the point would probably never have arisen. There's ample authority that a business that is temporarily closed can still be covered by TUPE. Part of the argument here against there being a service provision change was that the service provision change rules, which are British only, are separate from the rules on interpretation of TUPE, which of course has European origins. However, the EAT sidestepped this point by saying that even under English ordinary purposive interpretation, the court still got to a point where these employees were covered by legislation, which is expressly for the protection of employees. It is kind of difficult to argue with that point, I think. So, that's the case of INEX Home Improvements Limited and Hodgkins and others. Third and final case, Underwood and Wincanton plc. This is an EAT decision which looks at the public interest test in the whistleblowing legislation. As this is still, I think, a relatively new test, there's not been much case law in its ambit, and therefore this is a welcome decision giving some more light on the area. My friends, the libel lawyers, would like me to point out the case was a strikeout application by the employer, and so no factual matters have yet been determined about the underlying allegations. As they say, the case continues. Well, the requirement that a whistleblowing disclosure has to be in the public interest was inserted in the Employment Rights Act 1996 by the Employment and Regulatory Reform Act 2013. As a result, legal protection is now only given to those making protected disclosures if they reasonably believe these disclosures are in the public interest. The public interest test was introduced into the legislation following the case of Parkins and Sodexo Limited, and the aim was to prevent workers from making disclosures that were of no wider public importance but simply involved a breach of a personal nature. The reason for this is that in order to bring a claim for unfair dismissal, individuals have to have 2 years' service, but in order to bring a claim under the whistleblowing protection, an individual does not have to have any qualifying period. It's not necessary for the whistleblower to demonstrate the information being disclosed is factually accurate, or true, or actually in the public interest. All the claimant must show is that they subjectively believe failure occurred and that it was in the public interest to make the disclosure, and that the belief was reasonable. Since this matter was being argued in the context of a strikeout application by the employer, it was necessary for the court to be satisfied that the whistleblowing complaint had no reasonable prospects of success, and that is obviously quite a high hurdle to get over, but it is important to bear in mind when reading the full decision. The background facts of the case, the allegations, I should say, are relatively straightforward. Wincanton is a large road haulage company. Mr. Underwood was a driver for it for approximately 20 months before he was dismissed. He brought a whistleblowing claim at the Employment Tribunal and argued that his dismissal was automatically unfair. And this was based on a protected disclosure relating to an earlier complaint by Mr. Underwood and several others that overtime was being unfairly withheld from some drivers, possibly those who were keen to uphold the standards and policies in relation to the safety and roadworthiness of their vehicles. The EAT commented it was a little difficult to understand the precise nature of the alleged disclosure. Anyway, there were a number of reasons why the employer argued that the whistleblowing complaint should be struck out as having no reasonable prospect of success. But the key question from our point of view was whether the disclosure could be said to have been, quote, in the public interest, unquote, and therefore whether Mr. Underwood could be protected by the whistleblowing legislation. It's important to remember that Mr. Underwood could not bring a claim for unfair dismissal as he didn't have the necessary 2-year period. Well, the tribunal judge, found that Mr. Underwood had failed to meet the required public interest test. The judge held the dispute was by reference to terms and conditions of his own employment contract, i.e. overtime, and therefore could not be said to be in the public interest. As a result, the claim was struck out, and Mr. Underwood appealed to the EAT. Well, the EAT allowed the appeal. It held that the tribunal's decision cut across the EAT decision Chesterton Global Limited and Nur Mohammed, which was decided after the Employment Tribunal decision in this case. And if you'd like more detail on the Chesterton decision, we looked at this in podcast 69. In essence, the EAT, I'm sure undoubtedly correctly, concluded that the tribunal judge would have expressed his decision differently if he'd had the benefit of the Chesterton decision, and therefore it could not be said that the claim had no reasonable prospects of success. Therefore, the whistleblowing claims are allowed to proceed to a full hearing. The case is useful in that it solidifies the guidance given by the tribunal in Chesterton. And there are 2 key takeaway points. First, an individual only knows to show needs to show that he or she had a reasonable belief there had been some wrongdoing and that it is in the public interest. Secondly, only a small group of individuals need to be affected in order for the public interest test to be satisfied, and this can include a small number of employees at the same establishment as the individual. I think it's fair to say that as a result of these two recent EAT decisions on the public interest test, courts have clearly taken a very wide view of what constitutes the public interest. As a result, it's not difficult for an employee to get a whistleblowing claim off the ground. It doesn't matter that the primary reason for the disclosure is the employee's own interest or advantage, provided that a sufficient group of other employees are also affected. Therefore, employers should be aware that whistleblowing protection can be afforded to an employee even where only a small group of persons are affected by the disclosure, and even where the facts that the employee is relying on turn out to be untrue. I personally think it's quite questionable whether this can be said to be Parliament's intention when they introduced the public interest test. And actually, in this case, one of the things that the barrister representing the employer did was mount a full-on attack on the Chesterton decision, either arguing that it could be distinguished, so the EAT didn't need to follow it, or that it was simply wrong. More interestingly, perhaps, the EAT judge accepted that some of the arguments as to why Chesterton were wrong were arguments that he had sympathy with, but he didn't feel able to depart from the Chesterton decision. The Chesterton case itself is apparently listed for appeal in October 2016, according to the judgment in this particular case, the Underwood case. I confess, when I read this, I hoped that this was a typo for October 2015, but no such luck. It's floating between 11th and 12th October 2016. So for a year at least, we're going to have this case and the earlier Chesterton case indicating that the courts are taking a very expansive approach to the test of what is in the public interest. So that's Underwood and Wincanton plc. So I'm off to watch the rugby this weekend. It's going to be considerably less stressful, I think, than watching Scotland play Australia. And I'm pleased to say I managed to get New Zealand in the office sweepstake, and I'm clutching onto that ticket. I declined to swap it for the Scotland ticket that I was given, which would have, of course, been a worthless ticket in the circumstances. So I suppose I do still have some stake in this game. So until the next podcast number 81, thanks very much indeed for listening. Take care.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.